Welcome to American Law Café. Today, we're jumping into a really high-stakes legal maneuver. Think of it as a defendant's secret weapon, a move that can totally change the game and get them out of a potentially hostile courtroom. Okay, picture this. You're a defendant, and a lawsuit just lands on your desk. It's been filed in state court, maybe in a place that's known for being, well, very friendly to plaintiffs. You're already starting to sweat, and you start to wonder, is there a way out of here? Is there some kind of escape hatch to a federal court? The answer is yes, but you have to play your cards exactly right. So that escape hatch, it's called removal, and it's a power that only defendants have. It lets them literally pick up a case that a plaintiff filed in state court and move it, or remove it, to the federal district court that sits in that same area. It's the defendant's one shot to say, nope, I don't like your choice of courtroom, we're going here instead. But here's the catch. To use this escape hatch, you need a golden ticket. And in the legal world, that ticket is something called original jurisdiction. All this really means is that the case has to be something the plaintiff could have brought in federal court to begin with. You know, if the federal courthouse doors would have been open for the plaintiff, then they're open for the defendant to use for removal. So what gets you through those federal doors? Well, there are two main paths. The first one is called federal question jurisdiction. This is for cases where the plaintiff's whole argument is based on a federal law or the U.S. Constitution. Think civil rights or copyright law. The second path is diversity jurisdiction, and this one's got two parts. The parties have to be from different states, and the amount of money they're fighting over has to be more than $75,000. So really, it all just boils down to this one simple rule of thumb. Could this lawsuit have started out in federal court from day one? If the answer is yes, then removal is definitely on the table. That is the fundamental rule of the entire removal game. But just having that golden ticket, that's not enough. Now you have to run what I like to call the removal gauntlet. It's this series of super strict procedural rules, and it is a race against the clock. One tiny mistake, and those federal courthouse doors can slam shut forever. And this right here is the most important number in that whole race: 30. A defendant has just 30 days, that's it, to file for removal after they get served with the complaint. I'm not talking about a month or about 4 weeks, I mean 30 calendar days. If you miss it by even one day, that escape hatch is usually locked for good. It is one of the most unforgiving deadlines in all of law. Seriously. And beyond that ticking clock, there are a few other huge rules. First, there's the Unanimity Rule. If you have more than one defendant, every single one of them has to agree to remove. One person says no, and the whole plan is dead in the water. Second, it's a notice, not a motion. This is a subtle but important difference. You're not asking the court for permission, you're telling the court that you're removing the case. And last but not least, always remember, this is a power for defendants only. The plaintiff already made their choice when they filed the suit. Okay, but there's this massive exception we have to talk about, called the forum defendant rule. And it creates a really important split. Just look at this. If the case is about a federal question, a local defendant can still remove it, no problem. But if the case is purely about diversity, a defendant who gets sued in their own home state cannot remove. The whole point of diversity jurisdiction is to protect out-of-staters from local bias. So the logic is, if you're sued on your home turf, that risk of bias is gone, and so is your escape hatch. All right, let's flip the script. What happens if a defendant messes up and removes a case they shouldn't have? Well, the plaintiff isn't just stuck with it. They have a really powerful countermove to send the case right back where it came from, and it's called a motion to remand. The classic case on this is Avitts v. Amoco. So you had these landowners who sued Amoco in Texas state court for damaging their property. And in the complaint, there was this one single, vague little mention of federal law. Amoco saw that, jumped on it, and removed the case. But the court basically said not so fast. A nebulous referral just isn't going to cut it. The plaintiff is the master of their complaint, and they hadn't actually based their claim on any specific federal law. So this gets to the million-dollar question, or in this specific case, the $650,000 question. When a federal court finally realizes it never should have had the case in the first place, what's the fallout? What happens next? And the fallout was huge. First, the court confirmed it never had jurisdiction, and because of that, it had no power to do anything. So all the orders it had made, including forcing a very expensive environmental study and making one side pay $650,000 in fees, all of it was just erased, wiped from the record like it never happened. And then the case was remanded, sent right back to the Texas state court where it all began. It was a massive, expensive mistake for the defense. Now, the Avitts case was all about federal question jurisdiction, but getting diversity jurisdiction right can be just as tricky. A huge question that comes up all the time is when we're trying to figure out if the parties are from different states, who exactly are we supposed to be looking at? The Supreme Court really cleared this up for us in Lincoln Property Co. v. Roche. So, a family sued their landlord, who was from another state. Later, they tried to get the case sent back, arguing that maybe the landlord had some local affiliate who was the real party in interest. The lower court actually agreed with them, but the Supreme Court stepped in and shut that down. They laid down a super simple, clean rule. You only look at the citizenship of the parties that are actually named in the lawsuit. That's it. No digging around for hidden companies or playing guessing games.
So, after going through all this, after navigating this whole legal maze, what are the big strategic lessons here? What's the playbook we should take away from all this?
Okay, for plaintiffs, the lesson is crystal clear. You are the master of your complaint. As we saw in Avitts, if you want to stay in state court, just plead state law claims. Keep it simple. For defendants, the message is all about speed and teamwork. That 30-day clock is no joke, and you have to get every other defendant on board. And for both sides, the biggest takeaway of all is that subject matter jurisdiction is everything. It's not a small detail. It's the foundation of the entire case, and if it's flawed, the whole thing can come crashing down at any moment. So, I'll leave you with this to think about. Now that you know these rules, the power of the plaintiff to frame the case, the tricky exceptions like the forum defendant rule, how would you strategically write a complaint? Could you draft it in a way that pretty much guarantees it stays in state court? Or could you design it to make it perfectly ripe for a fast and easy removal to a federal court? It's a fun puzzle, and often the choice is yours. Hey, if you found this explanation of legal strategy helpful, please take a second to hit that like button and subscribe for more content from American Law Café. And you can find the American Law Café podcast anywhere you listen to your podcasts. We'd love to have you join us there. Thanks for tuning in.